Well, welcome to the Estates Made Simple podcast. My name is Gordon Vanderleek, and my co-host is here with me today, Jenna Carvello. How are you today, Jenna?
I'm great. How are you, Gordon?
Doing okay. We're doing okay. This is a interesting topic that we have today. I'm excited to get into it. The but just for our audience, yeah, we're wanted to share a little bit about why we started this podcast and sharing the information because we think there's a role to play to simplify the world of estate administration. There's a lot of complexity out there, and we can bring some clarity to it and maybe simplify it a little bit, help you in your role as an executor, or if you're considering being an executor. And that sort of fits with today's topics of, well, where could there be some mistakes? And we want to make sure you have all the right tools to be able to do your job. So a little bit about myself, Gord Vanderleek. I'm a local wills and estates lawyer here in Calgary. Have my firm Vanderleek Law, where we practice in the area of wills, estates, and trusts, as well as helping families that have children with long-term disabilities through a division of our firm called Disability Advocates. So we are in this world of estate administration, and I think, Jenna, when we talked about starting this podcast, you've been in this world too. So share a little bit about your background and how you got, in terms of the role of the executor and in the context of potential mistakes.
Yes. Well, thanks, Gordon. So I've been in this industry for about 12 or 13 years now, 10 of which I personally acted as an executor and trustee through a large major trust company. And then after my stint there, I opened a Guardian Estate Company, which really specializes in connecting executors to the right solutions to help guide them through the steps they need to take. And then as well for people planning their estates, providing them education and resources in choosing the right executor. So I love this industry. I love chatting about it, and I'm sure we'll get into a great discussion today.
Yeah. So what have you seen? Give it some opening thoughts with regard to common executor mistakes.
Yes. Well, I think to start off, one thing that a lot of people are not aware of is acting as an executor can bring on personal liability. So if you make a mistake, the beneficiaries can hold you personally liable to reimburse the value of that mistake to the estate. So that could be quite significant depending on the types of assets you're managing and the types of estate that you're going through. So we just really wanted to highlight the top executor mistakes to give you an idea of what you should look out for. So I think the first one, which I think gets overlooked, is, considering whether you should act in the first place,
Yep.
deciding to take on that role. And I think, Gordon, you probably have some comments on that too in your role as a lawyer.
Yeah, that is an important consideration. It starts with a principle that you may have been nominated in somebody's last will to be the executor. There's not an obligation on you to accept that. So the first issue is, do you agree? Do you want to be executor? But where we've seen a problem is that people eliminate that as a choice because they sort of jump in maybe a little bit too early, or they're not asking the right questions up front. Quite frankly, getting the appropriate advice up front about what they're getting themselves into. I think people feel a sense of obligation or maybe honor that they were named. Maybe it's their friend or relative, or maybe a little different dynamic when it's a parent, right? You're going to go, well, okay, this is something I guess I need to do. But what if it's your golfing buddy and you find out I've been named as an executor? So I think there is a danger, and the law is that you are allowed to renounce, but the court may not allow you to renounce if you've gone too far. So there is that concept of intermeddling. You've progressed too far into the role, and therefore you're obligated to carry on. So I think really framing that issue is to say, I mean, ideally you would know that ahead of time, and you would have asked the questions, and hopefully somebody asked you and you said yes. But even if you did before, I think it's appropriate to take pause in the very beginning to say, okay, what is going on here? What am I getting myself into? If there's tons of litigation, you're going to have to deal with that. Are you ready for that? Is it better to say, I just can't do it? I know I said yes, but and maybe there's this feeling of I'm letting the deceased person down, or you want to honor a promise that is made. But yeah, you have to be ready for it. And if you don't have the capacity, that could lead to problems. And we'll talk about that in today's episode. So I think have that sober second judgment right at the beginning and before you get too far along, because if you're going to renunciate, part of what you're saying is, I have not intermeddled. I have not, actually started into the administration, because if you want to get out, the court may not allow you. If you may have to apply to get out, or what if it's a contested situation and you've gone too far down the road, and now you're in a situation where you've actually done some things without legal authority, and you could be responsible for that, right? You run off and hire people, and then it turns out, what if they don't get paid and they're looking to you to pay, and you're going, well, no, I changed my mind. Well, as you say, that's a personal obligation. You can't hide behind a corporate veil for something like that.
And before you start taking any steps, I mean, it's actually quite simple to renounce your executorship. It's a one page document you sign off, and then your role ends, typically. So it's quite easy to do if you haven't taken any steps in the administration. And I think that's also surprising to a lot of executors to learn.
Yeah, because they sense of, well, if I'm named, I don't have a choice. So I think the message here, you do have a choice, and you want to get the appropriate legal advice, and other professional advice. You need to talk to, bring other professionals as part of the process. You don't want to be faced with a claim that, well, you failed to manage, or you didn't protect the assets properly, right? So I think it's one of those first questions to ask, and ask it early, and get appropriate advice, so you're aware of what you're getting into. You may have to do some inquiries about, well, what's actually involved, and do I have the time? What is this going to look like? Is it, there are some people who sort of do the role and say, I never want to do that again. It can be time consuming and very stressful. It can also be, I think, very rewarding. But again, the message would be, ask these questions at the front end.
Yeah. And then once an executor does decide to proceed and agrees to take on the role, another common mistake that I've seen in my history is executors fail to provide adequate and detailed enough communication to the beneficiaries. And without a lot of communication, there comes suspicion, lots of additional questions. Beneficiaries start getting worried. They don't know what's going on. So I think from a legal perspective, you do have requirements to advise beneficiaries and keep them accountable, and tell them about what's going on in the estate administration. But then also from more of a softer side, you just come into so many more issues if you don't provide transparency and you don't tell the beneficiaries about your tasks that you're completing. So at the very least, I'd recommend doing regular accounting of the transactions that's going on in the estate, specifically to the residual beneficiaries, those receiving a percentage share. I think quarterly or semi-annually is a good cadence, and as well as written letters about the tasks that you're undertaking and the steps that you're doing to complete the estate administration.
As you're talking, I'm reminded of certain cases I've been involved with, where I'm acting for the beneficiary. And usually the conversation starts going, I haven't heard from the executor, and they're not returning my calls or my texts, right? I have no idea what's going on, and I'm asking and they're not telling me, right? So as you say, that creates that suspicion, right?
Yeah.
Their brain goes probably to a worst possible scenario, which is maybe not even the case. But a failure to communicate usually results in a beneficiary going, well, if maybe I need to talk to a lawyer, so to avoid that scenario, we don't want to let it go that far. It also reminded me, point number 2 would be, there is actually a provision of the surrogate rules to say there's an obligation to report within 2 years of the date of the grant of probate, right? I remember getting an application where the beneficiary was suing the executor, and they had that as part of their court documents. they violated this rule. There's been no report within 2 years. The person goes, I didn't know I had that as an obligation, right? So again, obviously didn't get the right advice at the front end or wasn't aware of that. And typically estates may be wrapped up by then, but even if it's a longer estate with complexities, you just need to communicate and say, well, it's not happening yet because I'm working on this, this, and this,
Yeah.
right? And the beneficiaries would go, oh, okay, that makes sense. Get back to me in another 3 months, 6 months, but you've got to communicate. Not only, and it's helpful to explain, here's what's going on with a financial transaction, but you just have to report. And certainly more recently under the new Estate Administration Act, there is now, as part of the duties of the executor, an obligation to move an estate forward in as practical a manner as possible, right? Every estate is different. And, as the saying goes, you sort of measure time in the estate in months and years, not days and weeks.
Yeah.
Right? It's not a race and a speed to the end, but the reality is, if you don't communicate and you're taking your sweet time about it, you're probably going to you could get hauled in front of a judge and have to explain yourself. And that gets a little awkward because that's going to open the door for, you owe me damages because I've suffered a loss because I haven't received my inheritance in a timely manner. I could have invested it. I could have done this.
Mm-hmm.
And I'm going to challenge your compensation because I think you were negligent, right? You did such a bad job. I think you not only owe me money, but you're not entitled to be paid for your efforts because you really dropped the ball. I mean, these are the arguments that are made, right? So to certainly, if you say, well, that's fine, I could just do whatever I want, and as long as they get the check at the end, yeah, no, you've got to communicate regularly. And I guess to flip that is, how do you prevent that? Good and regular communication is really what the beneficiaries are looking for. They're probably thankful that you're doing the job because they probably don't want to do it.
Mm-hmm.
But you need to communicate, right? You have a lot of discretion, a lot of authority, but you do have positive obligations to communicate. And if you don't comply with those, you better believe the beneficiary's lawyer is going to bring that to the court's attention. And if there's no good argument or answer to that, well, now you've got an additional problem.
Yeah, well, and I think that goes hand in hand with our next common executor mistake of not hiring the right experts.
Yes.
So when you are involved in an estate, what typical experts does somebody need to consider when they're navigating their role as an executor?
I think when you're looking at the financial management of the estate, having somebody who's familiar with the responsibilities of the executor investing and getting a decent rate of return on the property in the estate, I think is really important, right? Sometimes a claim could be you failed to invest it, or you put it in too risky of a venture. You didn't take it out of there and liquidate to cash, and the market went down. We've all experienced some, market fluctuations in recent years, and if that happens to be under your watch, they will want an answer of why didn't you do something, right? So getting a good financial advisor in place, I would say the other one on my top three list, and then you can add to it perhaps, is getting an insurance professional involved. And I'm thinking about the situation of preserving the assets. If there's a house, is there insurance? What if the deceased wasn't making their payments on the insurance policy and they let it lapse? You've got immediate, and what if the place burns down and now you're answerable to the beneficiaries of saying, why did you, why didn't you insure it, right? So if there's assets that need insurance, you want to make sure it's in place and it's adequate, because maybe it's not, and you have to increase the insurance in the case of theft or fire. Is there insurance on the vehicle? If somebody gets a hold of the vehicle and steals it and gets into an accident, well, now there's a personal injury lawsuit, and guess what? The estate is named as a defendant. Well, now you're dealing with that, and the answer is, well, why didn't you get proper insurance? The beneficiaries may not be too happy with you if the plaintiff is going after the assets in the estate to pay the judgment rather than an insurance policy, right, to cover that. But I'll end on the the third one that comes to mind, and actually I leave it for the end because I think it's actually what I usually start with in the conversation would be get the accountant in early. I think you're for sure everybody has to file a tax return, right? But getting the right professionals. So I've seen situations where the wrong professional, the wrong accountant is involved, and there are some accountants that were maybe really good for the person along the way, right? In terms of filing their T1 tax return by April 30th of every year, but they're not aware of the rules for estates. I mean, one would hope they're aware that there's a rule about a deemed disposition that creates a tax consequence and that there's rollover provisions and we're maximizing the value of all those. But I think while the accountant usually has a bunch of work later on in the timeline for the administration of the estate, in some cases, and increasingly so, there is specific deadlines for filing documents with Canada Revenue Agency. So you don't want to miss those. So I think early on, get the accountant on board. Even if there is an accountant, make sure it's the right accountant, like they have experience with estate returns, because that's different than the normal returns we all file. There are special rules relating to estates, and that you're aware of what those deadlines are and you don't miss those. Because if you miss a deadline and now there's penalties and interests, then guess what? You're accountable to the beneficiaries for that, and they're going to say, well, you're paying for that. I'm not paying for that, right? So that would be a common. So I think early on, even though the accountant may not have a filing deadline for many months down the road, I think hire the accountant at the front end, so you can be advised as to any appropriate timelines, and that you make sure you don't miss those. And the person's going to guide you through all the tax issues associated with the estate, which, depending on what's in the estate, can have a level of complexity there that you just need advice on.
Yeah. Well, and I think, hiring the right experts does alleviate some of the liability on the executor because they're relying on the experts to provide them that qualified advice. Because executors aren't supposed to be experts in everything. I mean, who knows tax, legal, insurance, being someone that maybe has never been involved in those industries before. So a couple of other ones that come to mind, of course, is hiring a lawyer, such as yourself, Gordon, just to navigate different. Yeah, exactly. A little plug for you. But just to navigate the different legal issues. Maybe you're negotiating a lease agreement, or maybe you can't get a tenant out of a property. Having a legal expert on your side is important to help navigate those issues. And the other one is what we chatted about before too, is really getting correct appraisals on the assets held in the estate, whether that be real property, whether that be artwork, or an asset that's difficult to value. But hiring an appraiser that's qualified in that area is important, because if you wanted to sell the item and you sold it for below market value because you didn't know any different, that could bring on liability on your shoulders. So I think, those are unique cases, but something that people should consider.
If you look at it and go, you may say, well, I don't know anything about artwork. And you got to go, I don't know, I don't even like that painting. Well, what if it happens to be one of the group of seven, right? Canadian artists, and it's worth $60,000 and you sold it in the garage sale for $6. Well, the beneficiaries might have something to say about that. So yeah, absolutely. I think the theme here is you're not expected to know everything, but you've got to ask the right questions. You don't need to know everything about the Income Tax Act, but you have to know enough to be able to say, I need an accountant.
Mm-hmm.
You don't need to be an art connoisseur to understand the value of the paintings, but you do need to know enough to say, maybe I need a valuator, right? Because maybe how do I know what it's worth? Well, you're not expected to know the answer, but you're expected to go get the answer or find somebody who does, right? So you can rely on those professionals. And I do agree with you that to emphasize the point, one of the points you made would be it's good insurance, if you will, like it's a protection. You're not expected to be able to understand market fluctuations, but you do have a responsibility to manage that estate asset, right? So if you're going to go, well, I thought the markets would be fine and there's suddenly a downturn, I think it's a very different scenario going, well, I didn't think it was a problem, versus, Well, I talked to my financial advisor. They're well versed in this, and he told me to invest like this, and I relied on that advice. Right. So by hiring the professional, you're kind of hiring their insurance policy, their professional errors and omissions. Because if there's a mistake, the accountant makes a mistake filing a tax return, and you can say, well, I think you're responsible for that. So you're kind of buying into that insurance. So I really wanted to emphasize that point, that it's, you think, well, I can just do it myself and I'll figure it out. I'll save some money, but you're increasing the risk. And that's a common mistake, is you're going, well, I'm trying to save money, but it's at your personal expense, right? And it's just not pleasant to get into a scenario where you are being challenged on the judgments you've made on the estate, and getting in front of a judge, right? Going through the litigation process is time consuming, and it weighs on you. It's very emotionally draining. It can be financially devastating. But there's ways to responsibly do it, right? And I guess that's the message as well. I mean, maybe some of the stories would lead somebody to say, well, I'm taking the message as saying I should never be an executor. And I guess we're not saying that. But if you're going to do it well, right? Do it properly. And you should protect yourself. You're doing an important job, and you're entitled to protection. And these fees from professionals that are helping you are all expenses of the estate. It's not coming out of your pocket. It's coming out of the estate. And there's every reason to do it, and not a whole lot of reasons to cut the corners.
Yeah. Yeah, I completely agree. And I think that's a nice segue into our final common executor mistake, is not safeguarding the assets appropriately.
Yeah.
So if you have your professionals in place, but either you don't take their advice or you don't consider all the assets, that could cause harm to the estate. So two of the most common assets that a deceased may own is real property, of course. And you mentioned it before. If you don't contact the insurer and update that policy, certain losses may not be covered. So there's something called a vacancy permit in Alberta. Not telling the insurance company that nobody lives in the property anymore could prevent coverage on the property if there is, theft or fire or any sort of damage. So it's really important to safeguard that property. Contact the insurer right away if there is insurance in place, and if there isn't, get a policy in place as soon as you can. And then the other common error that I see is not reviewing the investments enough. And you mentioned that as well. Because a deceased may have been highly aggressive in the market, all equities, loved volatility, didn't worry too much about the ups and downs. But once somebody has passed away, the time horizon to recover from many of those losses has shortened significantly. Typically, if you have to disperse an estate within 1 or 2 years, you might have an inopportune time to sell the assets to distribute to the beneficiaries. So right at the date of death, you need to have a valuation done and then determine, okay, is this investment mandate still appropriate for the time horizon as well as the beneficiaries? Or do I need to reduce that risk to preserve the value of the estate? And again, because markets are so volatile right now, that could be a real big concern for a lot of executors and all stakeholders in the estate. So yeah, I always tell executors to watch for those two things specifically.
Yeah, your point being is your job is not to play the market and do stock picks, right? I really appreciate what you're saying. Let me, I guess, re-articulate it to emphasize the point is that there's a different standard if you're managing your own money versus managing somebody else's money, right? In the role of an executor, often referred to, they're in that fiduciary role, right? They're in a position of trust, and the law will impose a different standard in terms of risk tolerance. And that's where we get back to, you hire the right financial advisor because they should understand what that standard is and can give you advice, and you're entitled to rely on that advice. And that way, if there's a market fluctuation going, well, no one saw that coming. When suddenly there's a decline in the market, but yeah, it tends to be a more conservative position than what people may be accustomed to. It's not an answer to say, well, the person was in very risky investments, so I just carried on, right? There could be liability for that, and that's hopefully a proper professional on the financial side will give advice on that and protect against that risk, right? And say, well, maybe we should move more to a cash position. Balancing that with, you still have a duty to maximize the value of the estate and get a decent return, but you tend to be a more risk averse position, even if it's something that you go, well, that's not risky, because you would take that risk for your own portfolio, your own investments, but it's a different standard when you're managing somebody else's money. So that's an excellent point. It strikes me on the insurance side, or on the, with the insurance on the property, there's probably that sentiment of, well, if I don't tell the insurance company, they'll never know, and then it's not a problem. That if I actually disclose it, I'm creating a problem. So there's almost that feeling of, well, I'm just not gonna tell them, right? But that's an excellent point to say, you may be putting yourself in an off coverage position,
Mm-hmm.
and that could be huge, right? What if there is damage? We're recording this in the winter season. You hear stories of pipes freezing, right? What if there's some problem, or flooding or something like that, and the insurance company doesn't cover it? I mean, the cost could be in the tens or hundreds of thousands of dollars, right? So making sure you're adequately protected, so there's not a claim against you, and you'd say, well, I did something about it, right? You took some positive action. Because the standard is not perfection, right? The standard is not, there can be no mistakes, but did you take reasonable steps to mitigate those damages, right? And you
Yeah.
exercise judgment. And if it turns out you relied on professionals and there still turned out to be a mistake, like the estate went down in value, well, but if you got the right advice and you did all the right things, you're not negligent, right? The beneficiaries have to prove that there's a standard of negligence. You did not abide by the appropriate standard of what a reasonable executor would have done in the circumstances. That's to be said too. It's not you're responsible for if there's ever a downside, but you are responsible to ask the question and take reasonable steps.
Yeah.
To take that into account.
Yeah. And then record what you're doing too.
Yes.
Document the meeting you had and the discussion. And then at least you can show that you were aware and you had that conversation and protected against possible downside. So I think that's a really important thing to consider. And for all executors out there, think about these things before you start acting. And at the very least, seek out some help to get some advice. And we wish you the best of luck when you're doing your role.
Well, and especially in a situation where you may not be familiar with that, right? So let's say you've had no business experience, but the person died owning a business. Well, you need to go get the right business advice. So that's where getting the professionals surrounding you is hopefully creates a sense of well-being, or that, okay, I can get through this, and you're not doing it alone.
Yeah. Good points, Gordon. And well, it was nice chatting with you today about this very important topic. And for all of our listeners, we look forward to seeing you next time. Have a wonderful day.
Take care.